Hello, my name is Sujit Kunan. Welcome you to this tutorial on law relating to wildlife protection in India. Purpose of this module is to provide an understanding on the laws relating to protection of wildlife in India, and we also will discuss the context in which wildlife laws in India has been developed, and including in its historical context, and we will also discuss key issues and challenges, including the role of judiciary in the development of wildlife protection laws in India. The context in which the law relating to wildlife protection in India has been developed, if we look at these things, India contributes significantly to the biological diversity, even at the global level. For example, India is quite known for its rich wildlife diversity, and it's needless to explain the role of wildlife in maintaining the biological ecological balance. Means, if anything affects the wildlife, that can have implications on the overall ecology. So this is the context in which these wildlife laws in India, this is the context in which wildlife laws has been evolved, and that's also the case in India. So the rationale behind wildlife laws in India is mainly the extinction of species. A large number of species has been extincted, or many species are in the verge of extinction in the contemporary context. There are quite a few important reasons why this wildlife, many species are facing extinction. Most important is the habitat destruction. Habitat destruction means, for example, the situation of forest in India. Whatever affects the forest, that can have direct implication upon wildlife also. And another major factor affecting wildlife in India is hunting and also trade in animals. Trading in animals and animal stuff has been a major reason, even at the international level, that affects the overall health of wildlife, and that's also the case in India as well. So what we can see is, these are the major three important reasons probably why the wildlife law in India has been developed, that is habitat destruction, hunting, trading in animals. So what has been the legal responses to address these problems? When we look at a little bit in the historical context, wildlife laws in India is not a new phenomenon. It has been there even, the history of wildlife laws can even date back to the pre-colonial era. For example, Emperor Ashoka, during the period 296 to 77 BC, there are several edicts during the period of Emperor Ashoka that is directly linked to wildlife protection. For example, some of these edicts are directly related to prohibition of killing of animals. And when we move on to the colonial period, there are more than one laws relating to wildlife protection during the colonial period. For example, Wild Birds Protection Act 1887, and major purpose of this statute was prohibition of possession or as well as sale of certain birds during a particular period. Another major legislation was Wild Birds and Animals Protection Act 1912, and this was later on amended in 1935. This is a landmark legislation in the context that, this is the statute or law that perhaps for the first time introduced this idea of sanctuary. Sanctuary in the sense protected areas for conservation of wildlife. And this 1912 Act, Wild Birds and Animals Protection Act 1912, as amended in 1935, it also carried some provisions that prohibits killing of certain animals. And while this has been the pre-colonial as well as the colonial context, the independent India, the major comprehensive legislation was enacted in 1972, that was Wildlife Protection Act. In this module, we will be overwhelmingly focusing on this statute, that is Wildlife Protection Act 1972, its major provisions, its key features, as well as the role of judiciary or the jurisprudence developed upon this statute triggered by the Indian judiciary, especially the Supreme Court of India. Before we get into the substantive aspects of Wildlife Protection Act, let's have a brief outline of what is the constitutional context of wildlife protection in India, whether there is any provision in the Constitution of India that deals with wildlife protection. There are at least a couple of provisions that deal with wildlife protection. For example, I mean in the section on directive principles of state policy, there is Article 48A expressly deals with the duty of the state to protect wildlife. And similarly, in the section on fundamental duties of citizens, Article 51AG, it also talks about duty of all citizens to protect wildlife in India. So to emphasize these provisions, I mean what they ask is a duty from the state as well as from the duty of the state as well as of the citizens to preserve, protect and safeguard wildlife in India. And there is another section, another part of Article 51AG that requires all citizens, or that makes citizens duty bound to have compassion for living creatures. And this provision or this part of Article 51AG can be directly linked to this issue of cruelty to animals, because the word used in Article 51AG is compassion. That means, I mean, compassion towards animals, and that can be interpreted as putting a duty upon citizens not to be cruel towards animals. And there is another section, another provision in the constitution that is relevant in the context of wildlife is who has the power to enact law on wildlife protection. As you may already know that, I mean, there are certain provisions in the constitution that divides legislative power between the parliament and the state legislatures. For example, that means there are three lists: union list, state list and concurrent list as provided in the constitution. All those subject matters enlisted in the union list, the parliament has the exclusive power to make laws. Similarly, all those subject matters in the state list, state legislatures have the exclusive power to make laws. And as far as subject matters in the concurrent list is concerned, both the parliament and the state legislatures have equally the power to enact laws. So in this context, I mean, originally the constitution had included wildlife in the state list, and this scenario was changed in 1976 through Constitution 42nd Amendment Act, and through this amendment the subject matter wildlife was included in the concurrent list. So the legal implication is, as of now, the situation is both the parliament as well as the state legislatures can enact laws on wildlife protection. But however, as we look at the Wildlife Protection Act, this was enacted in 1972, the amendment was adopted in 1976. So when the Wildlife Protection Act 1972 was adopted, I mean the subject matter wildlife was part of the state list. That means in 1972 it was in the exclusive domain of the state legislatures to enact any law on wildlife protection. However, this 1972 Act is a central legislation. So we will just look at how it was possible for the Parliament to enact Wildlife Protection Act 1972. There is a provision in the Constitution, that's Article 252. According to Article 252, any subject matter which falls within the state list the law can be enacted on those subject matter by the Parliament, provided 2 or more states have passed a resolution to that effect. That means if states are willing, they can concede their power to the parliament, or they can permit the parliament to enact law. This is the context in which, or this is the provision through which the Wildlife Protection Act 1972 was passed by the parliament. And this, after 1972, this had undergone at least 4 or 5 amendments, that is in 1982, 86, 1991, 2002 and 2006. And all these amendments included a number of significant changes to this 1972 Act, and some of them are, for example, originally it was meant only for wild animals. So through these amendments, plants were also included, and originally and these amendments also tried to strengthen the power of the central government as far as this regulation or the protection of wildlife in India is concerned. There is a recent bill that is Wildlife Protection Amendment Bill 2013 is pending before the Parliament. So now let's have a discussion on the substantive aspect of Wildlife Protection Act 1972. What are the major purposes of this Wildlife Protection Act 1972? I mean, the major purpose, as it is clear from the title of the act, is to protect wildlife. And we had already mentioned, or we had already discussed this context in which this act was enacted, because many species were either extincted or in the verge of extinction. So the purpose of the act was to how to curtail or control this wildlife, and how to protect and conserve the existing population, or how to nurture the wildlife population in India. So the major legal measures, I mean, if you look at the substantive part of the Wildlife Protection Act 1972, the major legal measures are: one, prohibition of hunting of wild animals. This is mainly because hunting was considered, or hunting was one of the major reasons why this wildlife was wildlife population was affected. Second, the similar provisions are also there as far as these plants are concerned. For example, there are provisions that prohibit uprooting of plants. And the third major substantive measure is protection and management of wildlife habitats, because habitat destruction was one of the major reasons, one of the major threats for wildlife population in India. So Wildlife Protection Act 1972 introduced protection and management of wildlife, the natural habitats of wildlife, and this is mainly in the form of sanctuaries and national parks. And another major, the fourth major legal measure is regulation and control of trade in wildlife and parts and products, because this huge lucrative market for wildlife products or wildlife stuff, wildlife trophies, is one of the major reasons why wildlife population is affected. So Wildlife Protection Act 1972 has some provisions that regulates or control or prohibit trade in wildlife. And fifth major legal measure is again, it is related to the protection of wildlife habitat, but through I mean, this is mainly aiming to protect wildlife in captivity. This is mainly by establishing and managing zoos. So first, this regulation of hunting. What are the major provisions, or what is the nature of the provisions that regulate hunting in India? Because Wildlife Protection Act 1972, that follows a schedule system. It contains 4 schedules: schedules 1, 2, 3 and 4. And several, I mean, wildlife species are included in these schedules according to the nature of protection they demand. For example, if some species are really in the verge of extinction, probably a more stringent regulation or control is needed. Probably prohibition of hunting is required as far as that particular animal or plant is concerned. Whereas if some of them are, I mean, their population is relatively safe, but if some kind of regulation is not adopted, I mean, they might be pushed towards the extinction. In such cases, a lighter level of regulation may be necessary. In that case, this is the logic behind this having different kind of schedules. And as we move on from schedule 1 to 2 to 3 to 4, I mean, the standard or the strength or stringency of the regulation gets diluted. For example, the most stringent regulation or restriction applies in the case of schedule 1 animals. For example, I mean, the general rule is hunting of animals included in schedule 1 is prohibited, and this prohibition, however, is not absolute, and this is subject to some exceptions. For example, there are mainly 2 exceptions to this prohibition. That is, if hunting of schedule 1 animal is permitted if that particular animal has become dangerous to human life. 2, if that particular animal is so disabled or diseased as to be beyond recovery. That, as we can see, there are two critical conditions upon which hunting of schedule 1 animal is permitted. And one is if particular animal is dangerous to human life, and 2, the second condition is in the interest of that particular animal, because if that particular animal is so disabled or diseased, and then the possibility of recovery is either nil or extremely less. In that case, I mean, these are the 2 extreme situations in which hunting of schedule 1 animal is permitted, and one for protecting human life, for 2, I mean, in the interest of that particular animal. So that means, I mean, there's virtually no other situations where schedule 1 the hunting of schedule 1 animal is not permitted under the Wildlife Protection Act 1972. As far as hunting of schedule 2, 3 and 4 animals are concerned, I mean, this is more or less similar to what we had just discussed. However, the stringency is slightly diluted. As we can see, hunting of Schedule 2, 3 and 4 animals are permitted if there are 3 conditions. At least when compared to Schedule 1 animals, there is one more condition has been added. And that is the existing condition is like if animal has become dangerous to human life, that is to protect human life. Then the other is if that particular animal is so sick or diseased and the recovery is not possible, or the chances of recovery is extremely less. The third condition is this is the critical, the dilution part when we compare it to the Schedule 1 animals, that is hunting of animal listed in Schedule 2, 3 and 4 can also be permitted to protect property. This includes standing crops as well. So that means the relaxation, as you can see, is that it is not just for human life, but it's also hunting of Schedule 2, 3 and 4 animal is also permitted for protection of property, that includes crops. And this is in the context where animals, wild animals sometimes pose threat to agriculture or standing crops. So if it is Schedule 2 or 3 or 4 animals, and the hunting can be permitted as far as those animals are concerned if such animals pose threat to standing crops. There is another situation in which hunting can be permitted, that is for research and educational purposes. But there are several conditions to be satisfied as far as this issue is concerned. For example, permission of Chief Wildlife Warden is mandatory for permission of hunting for this research and educational purposes. Again, the purposes has been mentioned explicitly in the statute, and this includes quote unquote, it is education, scientific research, collection of specimens, or if it is for recognized zoos or for museums and similar institutions. And there is a third major condition situation upon which this hunting of animals for research and educational purposes is allowed is if it is for preparation of snake venom for manufacturing of life-saving drugs. So what we can see is hunting can be permitted. There are 2 conditions. It can be permitted only by the Chief Wildlife Warden, and this can be permitted only for certain purposes like scientific research and education, or for preparation of certain medicines like venoms. And if it is Schedule 1 animal, even for research and educational purposes, prior permission from the central government is mandatory, whereas for Schedule 2, 3 and 4 animals, this prior permission from the state government is required. This shows a kind of stringency as far as Schedule 1 animal when compared to Schedule 2 and 3 and 4 are concerned. For example, as far as Schedule 1 animals are concerned, the power has been vested with the central government, but whereas for other schedules or animals in the other schedules are concerned, prior permission, the power to give prior permission has been vested with the state government. So what we can see is, as far as Schedule 1 animal is concerned, utmost precaution and screening has been envisaged under the Wildlife Protection Act 1972. But however, there's one issue to be discussed is how central government is better than the state government as far as issuing this permit is concerned. Apparently, the Wildlife Protection Act 1972 seems to be following a presumption that central government is perhaps the best protector of the interest of wildlife when compared to state government. But there is no empirical evidence to substantiate this. However, this is one way that Wildlife Protection Act 1972 provides stringent regulation as far as hunting of Schedule 1 animals for research and educational purposes is concerned. And as I had already mentioned that Wildlife Protection Act 1972, even though originally it was meant only for animals, later on through an amendment, plants were also included. But as far as these plants are concerned, this also follows a kind of schedule approach as followed in the case of wild animals. For example, all regulations envisaged under the Wildlife Protection Act 1972 is applicable only to specified plants. Specified plant means plants notified by the central government. So what are the major legal regulations applicable to plants? One is destruction of specified plants. That means destruction of those plants enlisted in the central government notification is prohibited, and trading in those specified plants are also prohibited. That means destruction and trading are prohibited, apparently it presumes, or it is based upon the premise that this destruction and trading, trading is one of the major reasons why some of these plants are are being destroyed. And another major regulation is picking, uprooting and acquisition of against specified plants. In the case of picking, uprooting and acquisition, the regulatory approach is such actions require prior permission from the chief wildlife warden, and this can only be permitted for a certain purposes, that is educational and research and scientific research. Another major substantive part is habitat protection. As we had already mentioned in the beginning, habitat destruction is one of the major threat faced by wildlife in India. So Wildlife Protection Act envisages habitat protection as one of the major goals. And there are, in the Wildlife Protection Act, the habitat protection has been designed or envisaged as in the form of declaration of sanctuaries, national park, conservation reserve and community reserve. That means there are four kinds of protected areas envisaged under the Wildlife Protection Act 1972. So the critical questions in this context is how these protected areas are determined, who makes the decision, and what are the legal implications whenever there is a decision to declare protected areas, whether it is a sanctuary, national park, conservation reserve or community reserve. So we will discuss these protected areas one by one. First, national parks and sanctuaries. The major criteria for declaring any particular area as a national parks and sanctuary is where if that particular area is so crucial for sustenance of wildlife. So that means the idea behind is to find a natural habitat that is crucial for protection and conservation of wildlife, and then declare that particular area as a protected area. And this power to declare or power to determine and declare such protected areas, power to determine and declare national parks and sanctuaries vests with the state government. So that means the state government has the power to determine if there is a particular natural habitat that is so crucial for wildlife protection and conservation, and then they can declare it as a protected area, that means a national park or a sanctuary under the Wildlife Protection Act 1972. So then the critical question is, what are the legal consequences when they declare a particular area as a national park or a sanctuary? Four major legal regulations that are being applicable in the case of national park and sanctuaries is like restriction of human actions. One of the purposes for declaring a national park or a sanctuary is to restrict human interference in that natural habitat. This is partly because human interference or human intervention is one of the major reasons or one of the major threat for wildlife. And the second major major legal consequence is prohibition of activities that lead to destruction of wildlife, and it could be like clearing of forest or burning or cultivation, whatever. So, and the third major thing is prohibition of commercial exploitation of natural habitat, that means prohibition of commercial exploitation of that national park or sanctuary. And the declaration or the determination of national park and sanctuary also leads to restriction of several customary rights of for traditional forest dwellers or tribers, which includes grazing and private tenurial rights. So what we can see from these legal regulations is the primary purpose is to detach human beings or insulate the natural habitat of wildlife from human beings. So to put it in a different way, to completely prohibit or regulate strictly the human interference or human activity in the natural habitat of wildlife or determined wildlife habitat. The third and fourth category of protected areas is conservation and community reserve. And originally this idea was not in the Wildlife Protection Act 1972, and this was later on included through 2002 amendment, which came into force in 2003. The purpose of this is, the idea of sanctuaries and national park focuses on the natural habitat per se, and that means what happened to the adjacent areas. And this came, this idea of conservation and community reserve was adopted because of the realization that there are several adjacent areas that are also so critical for the conservation of wildlife within the national park or a sanctuary. That means this idea of corridors where wildlife quite often moves. So the moment they are outside the wildlife sanctuary or national park, I mean they may face some kind of problems, or they may face they may be unsafe outside those protected areas. So this was probably the idea behind this introduction of this conservation and community reserve. That means the purpose was to cover areas adjacent to national parks and sanctuaries, to cover areas that links different protected areas. So that means the second seems to address this issue of protection of wildlife corridors. That means the corridors through which the wildlife moves from one protected area to another protected area. Then who has the power to determine this conservation and community reserve? It is, I mean, Wildlife Protection Act in 1972 vests the state government with this power to declare conservation and community reserve. And the act also envisages the institutional mechanism for conservation and community reserves, that is Community Reserve Management Committee and Community Conservation Reserve Management Committee. That means a management committee for both conservation and community reserve. And again, I mean, this committee will be established by the state government, and the major purpose of these committees is to, or major function of this committee is to aid and advise the chief wildlife warden as far as his management and conservation of these reserves are concerned. But what is the difference between this community reserve and the conservation reserve? Conservation reserve is the idea if a particular adjacent place belongs to the government, and then that will be considered as conservation reserve. If it is a private land or a community land, then that will be termed as community reserve. And the major difference is, while the government can decide whether it wants to declare a particular land which is adjacent to a national park or sanctuary as a conservation reserve, it might face some problem if it is a private land or a community land. So the idea is, if it is a private land or community land, then the idea or the proposal has to come from that that particular private person or a community. And also the government that means the government needs permission from the community or the private individuals to declare or determine a particular area as a community reserve. So if you just look at some latest statistics, like what happened to this community reserve and conservation reserve, as on 2014, I mean, there are total 56 conservation reserves, whereas there's only 4 community reserves. So that seems to indicate that, I mean, this idea of community reserve is very difficult to implement, probably because it requires permission or consent from private or community land. And all these 4 community reserves were notified in 2007. So that means since 2007 there has not been any new community reserves, whereas conservationist reserve concern, it shows that the statistics shows some kind of consistent increase in number of conservation reserves. Now let's briefly look at this institutional mechanism as designed under the Wildlife Protection Act. There are a couple of institutional mechanisms designed under the Act. The most important one is probably, in addition to Chief Wildlife Warden and National Board for Wildlife and State Board for Wildlife, there is this institution called National Wildlife Crime Control Bureau. This was established in 2007, and its major function is to address the issue of crime or wildlife crimes. And its major function is advisory in nature. It collects and collates data relating to wildlife crimes, and it passes this data to the central government as well as the state government. So the idea is to provide statistics and knowledge as far as wildlife crime is concerned, so that the central government as well as the state government can take appropriate actions. Another major institution is Central Zoo Authority, And as we had already mentioned, because zoo is another major reason, determination or notification of zoo or maintenance of zoo is another major measure through which wildlife protection has been envisaged or wildlife conservation has been envisaged under the statute. That is, this Central Zoo Authority was established 1992 under Chapter 4A of the Wildlife Protection Act. The major purpose of this zoo authority is to recognize or de-recognize a zoo. That means it can recognize as well as de-recognize a zoo according to the standards and facilities available in a zoo. It can also lay down standards for keeping animals in a zoo. So that means the major powers, the regulatory powers as far as zoo is concerned, is vested with Central Zoo Authority. Another major institution is the National Tiger Conservation Authority. This was established in 2006 under Section 38O of the Wildlife Protection Act. As you can see, this is this is a species-specific authority. That is, it meant for conservation of tigers in India. So this could be partly because tiger is a national animal, or maybe the sustenance or a healthy tiger population in a habitat perhaps that shows the the overall health of that wildlife habitat or other wildlife in that particular habitat. What could be whatever may be the reasons, this authority specifically looks at tiger conservation in India. Another major contribution as far as Wildlife Protection Act or wildlife protection law in India is role of the judiciary. Judiciary has been playing significant role, significant role as far as this development of jurisprudence on wildlife protection laws in India is concerned. For example, there are quite a few important case laws that discusses either the scope or whether hunting can be allowed or not, or whether what kind of activities can be permitted in a natural habitat such as a national park or a sanctuary. So there are quite a few cases, but our purpose is not to discuss all those cases, or it's not possible to prepare an exhaustive list of all those cases that deals with. But what we are doing right now is to discuss some of the important cases and that contributed, so that it becomes an illustration like what kind of roles have been played by the judiciary, and that's also an indication at what kind of roles a judiciary can play in the development of wildlife jurisprudence in India. And one of the important case law, one of the important area where the judiciary has played an important role is appointment of chief wildlife warden. Even though it was mentioned in the 1972 Act, many state governments did not appoint chief wildlife warden, and that happened to be a major reason because chief wildlife warden is entrusted with several key functions under the 1972 Act. So if wildlife warden has not been appointed, the whole regulatory measures envisaged under the 1972 Act that affect. So in the Center for Environmental Law, this WWF case in 1997, the court issued a strong direction to all state governments to appoint chief wildlife warden. Apparently, this intervention by the judiciary brought about significant results as far as this appointment of chief wildlife warden is concerned. Another major role played by the judiciary was as far as the implementation of this 1972 Act is concerned. For example, again in WWF, this is the second case in 1992, the court identified there is a loophole in the implementation mechanism and directed the government to provide modern arms and ammunition or communication facilities to forest guards. And and this we can see that judiciary is slowly stepping into the area of executives and deciding or determining what actions are necessary for the proper implementation of the 1972 Act. In the same case, the court also directed to take steps for immunization of animals around protected areas. This was based upon the realization that there could be some kind of interaction between wildlife within the protected areas and wildlife outside the protected areas, or if we do not address wildlife outside protection areas, then it is possible that wildlife within the protected area could contract some diseases from other animals. So this was the context in which the court directed to take steps for immunization of animals outside the protected areas. Another controversial issue where judiciary had to face, or judiciary provided significantly or played significant role, is in the case of trade in wildlife. And the major issue in this context was, I mean, wildlife protection versus freedom of trade. Because as we had already mentioned, I mean, trading in wildlife is a lucrative business, and this was identified as one of the major reasons why our wildlife is facing extinction. And this happened, I mean, this case came when it came up before the Delhi High Court in 1994. The court categorically stated that, I mean, trade and business at the cost of disrupting life forms and ecology can't be allowed. That means the implication of this case is that, I mean, freedom of trade as envisaged or guaranteed under the constitution can't be cited as a justification for conducting trade in wildlife, or at least trade in those wildlife which are listed or which are protected under the Wildlife Protection Act 1972. Another controversial issue in the context of wildlife is tribals and tribals, I mean, wildlife protection on the one hand, and tribals and their livelihood on the other hand. This issue was raised in a case, Animal and Environment Legal Defense Fund case, decided by the Supreme Court in 1998, and this came up before the court regarding the permission of or granting of fishing permits in a reservoir within a national park. And in this case, I mean, the court approved the granting of fishing permits to tribals, and but however, the court also noticed that, I mean, this has to be managed with strong, I mean, this has to be strictly controlled, as far as because any sort of human intervention, I mean, according to the Supreme Court's perception was that any sort of human intervention in a protected area could be dangerous to the wildlife. So in that case, court also observed that ideally the government should have provided livelihood mechanism for all those tribals in a different area, not in a protected area. So the implication is that the hint from this case is that, I mean, if possible, there can't be any kind of human intervention in a protected areas. So there are quite a number of other cases where the judiciary has placed, but the major, I mean, to sum up, the major issues and challenges that in the context of wildlife protection is, again, I mean, to what extent we can balance wildlife protection on the one hand and the tribals and forest dwellers on the other hand. And another major issue highlighted, including in a government report, is, I mean, how we can design and determine protected areas according to ecological boundaries. I mean, that means to avoid artificial administrative boundaries. And again, another major issue is relating to tribals and forest dwellers' rights, is that how we can settle the customary rights of forest dwellers and tribals while we protect or designate particular areas as natural habitats and insulate those areas from tribals who has been living in this habitat for from time immemorial. Thank you.